Welcome to Dead But Not Gone, an estate planning podcast.
Welcome back to Dead But Not Gone, an estate planning podcast with Miss Allison Phillips. Allison is a Texas estate planning attorney and founder of the Burns Phillips Law Firm, where she helps individuals and families make thoughtful decisions that keep the people they love, out of court and out of conflict. I'm Evan Mack, and today we're walking through how probate works in Texas, what families are often surprised to learn about the process, and why so many people want to avoid putting their loved ones through it. Miss Allison, welcome back.
Hi, Evan. How are you doing today?
I'm well. So this probate thing is one of those legal processes where, people hear about all the time, but many families don't fully understand it until they are suddenly dealing with it themselves. What is probate actually meant to accomplish in the state of Texas?
So, probate is a court process. It's a legal proceeding, and if you're going to drill down to what it actually is it is the process, the legal process to transfer assets from somebody who's deceased to the appropriate party under the law.
So with that being said, what actually determines whether an estate has to go through probate in the first place?
It varies by what kind of assets a person has, what kind of documents they had. Probate is at its core going to court and standing in front of a judge and addressing the court, which that in and of itself terrifies people at the thought. So whether or not your estate has to go through probate depends on whether or not you want it to. You can
Mm,
choose to avoid it during your lifetime if that's your choice. There are assets that are what we call non-probate assets because naturally, by the way they are structured, they don't go through probate unless, some worst case scenarios pop up. Um, but, like life insurance, those are beneficiary designation accounts. Retirement, some investment accounts. If you have properly executed pay on death beneficiaries and you've done your beneficiary planning strategically, then those can pass outside of probate. But when I say if you've done it properly and strategically, is I do get people who tried to beneficiary plan who come to me thinking that, they have a will, but they don't need to probate it because everything was beneficiary plan. So they just need the will to, activate everything and get everything going. And learn that it's not sufficient. Something wasn't filled out
mm.
right. Something didn't get properly designated. Somebody checked the wrong box somewhere, or a beneficiary predeceased the deceased. So the designation outlived the beneficiary. Those are some of the things that I've seen that can go wrong in beneficiary planning that can shoot your non-probate assets over into probate. Your real property, depending on how it's titled, is what kind of dictates whether or not it's going to have to go through probate, and what documents you chose to execute during your lifetime.
So, Miss Allison, when a family is suddenly thrown into probate after losing someone, what are they usually trying to figure out in those first few weeks?
Those first few weeks are they're rough. And I mean, not just because of the probate or anything like that. They're just generally rough for people for having to experience loss. Grief is its own beast. Everybody processes grief differently. And when you have to throw in preparing for probate rather quickly, then it can really create some negative situations for people, both within their personal interactions with family as well as just their own personal traumas. So you're dealing with high emotions, very high emotions, and raw, very raw. It just happened. They're not only grieving the loss of their loved ones, they're also grieving the loss of the future that they thought they were going to have, either
Mm.
with their loved ones or moving forward in life. Their picture has now changed, and it changed for many, and unexpectedly. So there's that element. But then there's also the element of all of their accounts, depending on how they're titled, accounts are frozen. Bills are coming due. They don't want to see the house foreclosed. So they are being pushed to get probate going faster because it's the only way to get access to the accounts to be able to make these payments. And now they're like, okay, I really wanted to take some time to spend with the family, to be able to focus. And they're like, but I don't have time because I can't afford to pay the bills out of my own pocket until I have time, until I feel like opening the probate. So I have to get the probate going so that I can get access to the money, so that I can keep things from getting foreclosed or repossessed or anything like that. So then you have the element that they are feeling rushed. And that's where you see overwhelm happen. When you have grief, you add overwhelm, you get conflict. Conflict with their attorney, conflict with the court, conflict with each other. Any one of those avenues can create difficulty. And then you consider that if they want to open the probate and that also means that they are triggered on deadlines. And now they not only have to open it, but they're going to have a process that they have to proceed down. It's not a let's open it to get access to the accounts and then sit on it for a minute. Nope. You're doing it the way the process says you're going to do it. The probate means that you have to, depending on what kind of documents are in place, depends on what kind of probate you're doing, and what kind of requirements of the executor there's going to be and who the executor is going to be. You are going to have to start looking for credits. What kind of creditors are out there, what kind of debtors are out there. You got to start trying to find their liabilities that are going to be applied to the estate. But you also have to find the assets. This is the point at which somebody who is not you now has to try to navigate and create and understand your financial picture, and they don't have you to guide them for it. So, all those piles of paperwork in our house, we've all got the junk room where you have stuff you can't throw it away. You're going to need it. But you also don't have the time to figure out what to do with it. So it just piles up in those piles in the corner of the junk room that you close the door and hope nobody ever notices. Well, now your family's going to be in there. They're going to be digging through every one of those piles, the stuff that you didn't have time for, but now they have to make time for. And it's not even theirs. They've got their own piles, but they're going through yours because they're trying to figure out what kind of accounts you had. They're looking for
Mm.
passwords. They're trying to figure out how to access your banking information. What kind of property you owned. Where all was it? You're the only one who knows what kind of financial decisions and steps you've taken in your lifetime. Now they're trying to basically become investigators into your life to work backwards to what all you've got. This is so critical. And so I actually was reading a report not too long ago, and to give credit where it's due, it was empathy.com. They did a nationwide survey that they titled the Cost of Dying Report. There was a lot of numbers in there that were mind-boggling. It was nationwide, so you're looking at nationwide averages. So you're accounting for probate hostile states along with probate-friendly states like we are. But the number that I pulled that I found the most egregious, it was about the average time spent by families to administer an estate after a loved one has passed.
Mm.
And they estimated an average of 420 working hours. That's 10 and a half work weeks that you're dedicating of your time going through those piles of paperwork, waiting on statements to come in the mail. And if you think about it, in the old days, they used to, when they were trying to figure out mom and dad's estate and what kind of assets they owned, you would watch the mailbox and you'd sit and you wait about a quarter. You'd see all the statements and the summaries and the bills and everything come in, and you'd collect them and you'd catalog them. And then that's what you would probate. That's how you generated your inventory for probate. But now we are in the era of e-statements, paperless billing, um, and electronic online banking.
Mm.
So they may never get access to your email. And if you don't keep a list of passwords and they don't, or if you keep one and they never find it, then they may never be able to access your online banking accounts to get statements, and if they don't even know that that's your bank, how do they know to look there for statements, right? So, last time I looked, the Texas Department of Unclaimed Property had exceeded $9 billion. That's $9 billion that belongs to people that aren't the state, that the state is holding because either they don't know they don't have it, they haven't laid a claim to it, or they don't have the legal authority to make a claim to it. And I think we're going to see that number skyrocket. Personal opinion, obviously, but I think we're going to be seeing that number skyrocket here in the near future because of the era of e-statements and paperless billing. You can't watch the mailbox anymore. And if you don't have the right documents, then you can't get access to what they have. And if you don't have any way to know what they have, you don't know how to get the documents you need to get the access. So I think that we're going to start seeing and we're going to have to start coming up with creative solutions to deal with that. Because, once the probate is done, if it wasn't on the inventory and appraisal, it wasn't handled. And that's a whole nother issue on whether or not they can ever get access to that. So, if they find it in 5 to 10 years when they probated right after the death and they didn't include it on there, that's going to be a whole nother can of worms, essentially. So, that's one of the reasons my clients, I do an inventory. When we're part of a comprehensive estate plan is going to be cataloging and inventorying your assets so that your loved ones have a starting point. And the best person to answer any question about your finances is you. But if you wait till after you die to deal with it, then they have to deal with it. And they may not get what you think they're going to get because they may not know you have what you have.
So are there situations where probate itself is fairly manageable, but the real difficulties come from, missing documents, unclear wishes, or, disorganization even before things get started?
Absolutely. Absolutely. One of the main factors about how much probate is going to cost is what kind of documents did the decedent have. Um, if you had no planning in place, then it's going to be more expensive. It's going to be a lot more expensive to probate. If you had documents, but they were not well organized and they weren't well thought out, and they don't have all of the processes that are available to us to make the process easier, then, they can help, but they aren't necessarily going to make it easier. We are very lucky. There's a reason Texas is called probate friendly, and I do often put that in quotes because probate is still a court setting that still terrifies people, and there are many people out there that are like, there is no way any part of that is friendly. But we're classified probate friendly because our legislator has given us tools to make probate a little bit more streamlined, a little bit less overwhelming, and a little bit more smooth. And as long as you're working with somebody who knows how to structure those tools and how to utilize those tools and how to guide you in those tools, then yes, probate doesn't have to be the horrible, horrific experience that so many of the people we know are willing to tell us about. I do get a lot of people who come in here and they're like, I just dealt with my parents' estate and it was awful. It was awful. Or I just watched my friends go through this situation with their family that was devastating to them and eye-opening to me because I never dreamed it would have happened that way. And I want to make sure that doesn't happen to my people. So what do I need to do? So people are recognizing it. I try to disseminate knowledge about this because I don't want you to have to live through a horror story to realize that it needs to be done. And I don't want you to have to watch your loved ones live through a horror story to realize that you don't want that. So, it's all
Mm.
about, learning what's going on, learning how it works with a plan. And if your plan is the probate plan, that doesn't mean it's a bad plan. In Texas, especially, it can still be the right plan for you. It's just making sure that that plan is comprehensive, that it has everything that they need to get everything done, and also that it communicates clearly what you want to see happen so that you can remove all of the arguments of she told me this, I think it should be this way. He told me that it needs to be this way, or that's just not the right way to do things. I don't think you should do that. All of those conversations that people have when there's no instructions, they're off the table. It doesn't matter how you feel about it. This is what I chose. And this is what's going to happen. And you don't need to have any resentment for anyone who is handling this or taking care of this. If you're going to resent anybody because you don't like the choices I made, resent me. I don't care anymore.
Mhm.
But please don't take it out on the people that I'm leaving behind.
How do these trust and other estate planning tools change? What happens after someone passed away, compared to relying entirely on probate?
They make a significant impact. Like I said, not having documents is a guaranteed probate plan, and it's not going to be a cheap probate. whenever there's no documents. A lot of more steps, a lot of more processes, a lot of more hurdles that you have to get through. Um, Trusts are not the probate plan. If a trust is properly created, if you want to avoid probate, if you're hearing horror stories about probate and you know you don't want your kids to go through, probate is public. So everybody knows what you have, everybody knows what's passing through probate, and everybody knows who's receiving what. So sometimes I get parents in that they're like, I don't want people to know that my kids are getting whatever I'm leaving them. I don't want them to become victims of predators. I don't want people trying to insert themselves into their lives because they know they're coming into these assets. So, sometimes parents come to me and they're like, I need to do whatever I need to do to make sure nobody knows what my kids get from me and that it's smooth. And if we can avoid court, that'd be great. And in that case, trusts are great tools because they're private and they are not necessarily public record. Unless there's litigation that arises out of them. Most of the time, they're not public record, as if they're processed properly and written properly and drafted properly, and they do what they are meant to do. You can make sure that your kids receive what you're gifting to them in the way you want them to receive it. So they don't necessarily get it outright at 18 if that's not what you want. Um, they might have to go to college first. They might have to spend a certain number of years in their career before you're willing to let them have everything outright. Or you might want to keep it in your trust for their entire lifetime and make sure that it's there for their benefit, but not subject to them wasting it or losing it or um, draining it. You have a lot more control. So, yeah, there's a ton of tools out there that you can use. And I mean, even if probate plan is your plan, you can build things into your documents to make that process so much more smooth and easy for your loved ones so that they don't have to spend the 420 hours settling your estate. They don't have to be shelling out half the estate to pay for all the fees and costs associated with the litigation that might come from it. So, and that's why I always say a good estate plan, you're hoping for the best, preparing for the worst. Um, if it's comprehensive, there may be portions of it that are never necessary. You never need it,
Mm.
but you have it if you do, and they have it at their disposal if they need it. And it'll account for clarity for everyone who is conducting a position if they have a job to do. Um, it clearly articulates what you want happening with your kids, what is, in your opinion, they're in their best interests, and removes all of the struggle and conflict.
That's good stuff. Then to kind of wrap this up, after someone goes through probate with a parent or a family member, what do they usually become much more intentional about in their own planning?
Usually making sure that those tools that would have been easier if they had them are in there. So a lot of the times people will come to me, something simple like a self-proving affidavit. That's just one little bit that you can add on to the tail end of a will to reduce witness testimony and who has to be present for different hearings. And it's very simple. But if you're not an attorney and you're not familiar with the process, you don't know to put that on there.
Mm.
So, like picking one very simple, very small element that you can add with knowledge would be this one. But there are so many things that you can draft in there to just make sure that certain complications don't happen, or if they do happen, it's already handled. It's already instructed on how to handle. They don't necessarily know all the tools. They don't necessarily know what they needed, but they'll come in very intentional of, I've been through this and I don't want that. I have this situation. I'm already seeing the issues, just dealing with it myself right now while I'm alive. So I want to make sure I button that up and it's taken care of before anything happens to me. And I want to make sure that these people that are going to be my beneficiaries, whether it's your kids or your loved ones or your nieces or nephews or your brothers and sisters who or your best friend, whoever you're leaving your estate to, I don't want them to have to deal with this. So I want to go ahead and clean all of this up so that when I am done, after something happens to me, after I've passed away, if I'm incapacitated, I have the documents in place that the right people are making the right decisions. I have the documents in place that everything transfers the way that I want it to transfer. And I have a gift to give instead of a mess to unravel. And my legacy, this is my legacy. It's not the house you're leaving behind. That's not your legacy. It's a part of your legacy. The documents, the estate plan that you execute, it's a part of your legacy. Your legacy is the way people remember you, the feelings they have when they think back on your experience, their experience with you, their memories of you, those feelings in their heart. And what you don't want to happen is that feeling to be colored with, man, after they died, I went through the worst experience of my life.
Mm.
You want to preserve it. You don't want it colored. You don't want it broken. You want to preserve your legacy in their hearts. So you can do that with a comprehensive estate plan as much as the law will allow you to.
Good stuff. Miss Allison, thank you so much.
All right. Thanks, Evan. I appreciate it. I can talk about this all day.
It's good, though. It's good information for people to have, though. It is. Thank you so much. So that's it for today's episode of Dead But Not Gone, an estate planning podcast with Miss Allison Phillips. If you're ready to make thoughtful decisions about your future and create a plan that protects the people you love, visit bplestateplan.com to learn more. Thanks for listening, and don't forget to subscribe to the show, share the show, and leave a review, and we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.